solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. Thank you. Mr. Falcone, welcome to Department 8. Please have a seat.
All rise. Second Judicial District Court, State of Nevada is now in session. Honorable Barry Breslow presiding.
Thank you, everyone. Please be seated. All right, we're on the record in CR 19-1535A and B, State of Nevada versus Roger Hillygus and Stewart Handte, both of whom are in the courtroom. Mr. Hillygus is self-represented in custody. Mr. Hante's out of custody, represented at this point by Mr. Silverberg. The state is represented by Mr. Stege. All right. Much to discuss today. I'm going to go over the court's list of things that I want to either address today if we get to it, but if not, the court is going to set a hearing a week from this Monday. The date of that would be Monday the 21st. Monday the 21st of August 9:30, which is 1 week before the trial begins. Now, next week, this court is not available. I'm here, I'll be working, but I start tomorrow picking a jury for the trial that's all next week, 15 count, category A, criminal justice case. That will take up the court's entire week with very little time to address anything else other than things that absolutely cannot wait. So we're going to discuss today things, and then we're going to have a hearing Monday. Indeed, the week before trial, we're going to have a second hearing on Wednesday, the 23rd. Why 2 hearings and why those 2 days? Those are the only 2 days that week the court's available. And in a moment, I'll go through the issues that I want to address at some point on those days. In a moment, we will turn to Mr. Silverberg's motion to withdraw. Mr. Silverberg cited to the Young versus State case. Because issues with respect to his relationship with Mr. Handte will be discussed and addressed. When we get to that in a few moments, I'm going to have everybody leave the courtroom, because including the prosecutor and including Mr. Hillygus, because these communications will be closed. They're not open to public view. But before we do that, I want to go over the list of things that are going to take up our time today, Monday the 21st, Wednesday the 23rd, in advance of the Monday the 28th of August, beginning of the 2-week trial. Number 1, whether we're going to have an anonymous jury. The court has authority in certain cases to order that the information contained in the veneer questionnaires be redacted, to leave out the names of the veneer men and women, their date of birth other than the year they were born, their address other than the city and zip code, their phone numbers, things like that. So that neither the parties or anyone else interested in this case has an opportunity to know who those people are. Rather, they're just identified by their badge number. The hearing on whether the court will proceed that way is going to be Monday the 21st at 9:30 in the morning. So think about what your positions might be. Think about what points you might want to establish. Think about if you are in favor of that or against it. I will direct everyone's attention to a fairly recent case from the Nevada Supreme Court that spoke about that. It was a Department 4 case. Judge Steinheimer presiding. She was affirmed, I believe. Menendez Cordero, found at 135 Nevada 218. 135 Nevada 218. It was a 2019 decision of the Nevada Supreme Court. So look that over between now, please, and the 21st, and that can inform both sides, all three sides, on what the law is in Nevada. At that hearing, I'm also going to order that a representative from the Washoe County Sheriff's Office be here and be prepared to answer questions under oath with respect to issues that they have encountered, if any, with Mr. Hillygus while he's been in custody, or with Mr. Handte while he was in custody. So, anonymous jury, court will decide that from the bench after the hearing, Monday, the 21st at 9:30. Now, whether it's an anonymous jury or not, Wednesday the 23rd, I'm directing everyone to come back to court. And the court will hand out to both sides a printed out version of the jury questionnaire packets. So all sides get them at the same time. If it's not an anonymous jury, well, you have the veneer men and women. You can research them like you do anyone else. Off you go. On the other hand, if they are identified only by badge number as a result of the court's ruling on Monday the 21st, then each side will get their redacted set at exactly the same time. Wednesday morning, that hearing also will be at 9:30. The cameras during the trial. Now, I realize the court indicated today we would address that. The court still intends to. I know people are here that may want to testify. But it's likely the court does not make a decision today. It's likely the court will take evidence and argument today, and then, as furthered by anything that is decided on the issue of an anonymous jury on Monday the 21st, and then at that time as well, on the 21st, decide whether cameras will be allowed into the courtroom or not. If they are, of course, any media representative is bound by relevant restrictions on things like, I'm not patronizing, people understand in this profession what's allowed and not, but it just helps to remind us, if cameras are allowed, you never can pan on the jury. The question of whether you would be allowed during the jury veneer process, also, that's something that the court would have to consider in light of its decision whether this would be an anonymous jury or not. That's why I really cannot decide that question today. Exhibit marking. So while you're here on Wednesday the 23rd of August at 9:30, in addition to getting the jury veneer packets, you're also instructed to mark exhibits with the court clerk. And just to remind everyone, each side is able to mark proposed exhibits. Parties are encouraged to stipulate as to authenticity, if they're able to, admissibility, if they're able to, but if not, not. But they all have to be marked. Everyone gets a copy, so we have a list, and we can orderly identify which exhibits, audio files, video files, writings, text messages, interviews, if any, will be introduced at trial. So that all has to happen Wednesday, beginning at 9:30. Be prepared for that. I don't know if anybody is suffering from any physical limitations or disabilities. There has been at least one instance, maybe two, where one or the other defendants appeared in a wheelchair. I believe I've already indicated that if either is intending to appear at court for any proceeding in front of the jury in a wheelchair, the court has to approve that and have some basis to allow a wheelchair in the courtroom. Some medical reason, some ADA reason that would be allowed. No one, if somebody shows up in a wheelchair and the court hasn't been made aware of it and approved it in advance, we're going to have a hearing outside the presence of the jury and have to decide whether that's allowed. But I can tell you that in the absence of a medically indicated reason, the court is not intending to allow it. The court intends to issue an order as soon as I can get to it, probably very early next week, during a break in the trial that I have starting, that there will be no use of cell phones in the courtroom whatsoever during the trial. During recesses, sure. Before, fine. Afterwards, probably fine. But no use of cell phone. Nobody who is going to watch this proceeding can be on their phone, speaking, texting, and of course, no taping the proceedings on a cell phone. Aside from the court ordering that right now, that's prohibited, Nevada Supreme Court Rule 229 prohibits it in the absence of court approval, which the court is not giving. So if anyone who's here now, or anybody who may come, or any counsel, or Mr. Hillygus has any communication with people that want to observe the trial, I mean, the courtroom's open. And I'm not taking the cell phones away. I'm not putting cell phones in one of those sealable bags. I'm not doing that. That's not this case. But no one's going to be on the cell phone during court proceedings. It's inappropriate, disrespectful, distracting, and the court doesn't allow that. And I want to make sure people understand, I'm not directing these comments to any particular individual associated with this case. This is the court's order in every case. This is the court's decorum order. I'm just reminding people, no use of cell phones during the trial. Okay, gallery. People are free to come in and watch the trial. They have to follow the rules and the attire, no shorts, no tank tops. That's not going to be an issue. But I can tell you, if we have for the seating the jury, the veneer process, there might be a lot of people in here. And if we run out of seats, and if you're not one of the people selected for jury service, you're going to have to either wait outside until we have more available seats, or maybe stand against the wall until we have a seat open. But if we run out of bandwidth here for people to sit down, first preference goes to the parties, their maybe immediate family, and to the veneer men and women. So not being disrespectful to anyone who wants to watch the proceedings, but they may have to wait outside until we have enough room. I'm going to address with Mr. Hillygus in a little while his courtroom attire. He doesn't presumably want to come to court for a trial wearing jail garb. He wants to be wearing clothes appropriate for the courtroom. So I'm going to ask him shortly whether he's anticipated that and what his plan is. I realize it's restrictive. He's told the court repeatedly he's not domiciled in the Republic of Texas, and so I don't know if he has professional clothes to wear to court or not, what his plan is, but I want to make sure that he has the opportunity to be dressed appropriately for court. Mr. Hante's ankle monitor, I want to talk about that. I'm prepared to consider, we'll have the discussion on this on Monday or Wednesday of the week before trial, where it can be removed during trial. I don't want him to, A, be thinking about it, B, I don't want the jury to see him having that on and any negative connotations that go with that. I have another trial coming up where I have a similar situation, and what we did ordered in that trial, that the accused go to sober 24 in the morning, right before court. They take it off, and then he's in court during the proceedings, like Mr. Handte, out of custody, and then when court is over, he goes back down there. I've given thought to possibly allowing Mr. Handte to have that removed the Monday before trial, keep it off the whole week, and then put it back on Friday afternoon. And so my mind isn't completely made up on the everyday option as opposed to the weekly option, and then have it back on for the weekend. So think about what your position will be as to that. But I recognize that Mr. Handte has been displeased with the court's decisions on having him wear that over his objection, and I want to make sure it doesn't work to his disadvantage in any way during the trial. Order will come out shortly about courtroom decorum. Don't talk over the court, don't argue with the court, argue to the court. As to Mr. Hillygus, I will remind him shortly, I'll do now, that his argument that the court lacks jurisdiction has been made repeatedly through these proceedings. It's preserved for the record. You do not, Mr. Hillygus, need to reaffirm that every time to make sure that your position is known, understood, and preserved for any appellate review, if there's going to be any. So the court would deem further statements to that effect, or reminders of your view of the court's lack of jurisdiction, to be improper and potentially contemptuous. So, I'm likely, if it comes up from this point forward, to give you one further warning. After that, there will be consequences. I don't want that. I don't think you want that. Your position is known, and it's preserved for the record. Second. Okay. Trial week, beginning Monday, August 28th. And we start at 9. Courtroom will be unlocked and ready to go by 8:30 to set up. Let's actually, now that I think of it, let's go back to the Wednesday before trial when you're getting the jury veneers, either redacted or not, and you're also going to mark exhibits. The court directs that if the state intends to have a technologist here to help set up over an Elmo or screen or something to play audio or video or show exhibits, that not only does it need to be set up, but how it can be used either needs to be explained to defense counsel or defendants if there is no defense counsel, so that they can use it. Or alternatively, during the trial, if they need to use it and they can't grasp it, then Mr. Stege, the court would direct you. I know you're professional and would do this anyway, but would help them out. If they want to show Exhibit 2, you help them put it up there, things like that. But Wednesday before, we're going to check out how these monitors work and how they can be used. So that's really the third thing for that Wednesday. Jury input questionnaires, mark exhibits, and technology in the courtroom. Mr. Handte has previously filed is there something else? Or okay. Mr. Handte has previously filed a motion to change venue. The argument being that with pretrial publicity, he's concerned he might not have the opportunity to have a fair trial. The court, consistent with Nevada law, has said that it's holding that determination, the expression, in abeyance. It's on pause. The court will address that if asked to, again, after the jury selection process, after the voir dire, I should say, process. If the defense believes, either defendant believes that they cannot get a fair trial based on the manner in which the jury questioning process went, they can ask the court for a hearing on that. We'll take it up and the court will make a decision whether to transfer this case to another jurisdiction. The court reminds both sides that there's legal authority on that needs to be followed, showing that needs to be made, who has the burden of making that showing, and also that the pretrial publicity is not a product of their own doing. Because even if there is pretrial publicity that could affect the case, the court has to determine from what cause or source, if it's able to. So that's still out there if and when. And then, of course, we are set today for the so-called motion to confirm, which really is a question to both sides, all things being resolved here on attorneys, exhibit marking, things like that. Are we ready to go? Is there any legal impediment, things beyond your control impediment, family emergency, other trial that ran long? I mean, things like that that you can't anticipate and cannot handle. If there's something like that, the court in such a case has postponed a trial for a few weeks to let whatever was going on get wrapped up. If we just want to postpone it because we want to postpone it, that doesn't carry any weight. All right. I may have overlooked something, but those are the issues the court wants to address today. Monday, the week before trial, the 21st, Wednesday, the 23rd. In a moment, I'm going to excuse everybody and talk to Mr. Silverberg and Mr. Handte. But before I do that, Mr. Stege, any comments or questions about anything the court just said?
No, I would, on the young matter, I may have something to say about that before I'm excused. I wonder, I know there are people here on the media matter. Does the court want to handle that so they can?
I don't, because I don't know if Mr. Silverberg is going to be here as an advocate for Mr. Handte on that issue or not.
Okay.
So I really, with all respect to people that have marked this time out of their day to be here and be heard, I need to handle this other issue first. And if I'm understanding from prior matters, your position on this might be that the prosecutor shouldn't necessarily be excused from a hearing, like a young hearing like the court's about to go into.
Right, not in all instances, and of course, the state has an interest in avoiding unnecessary delay. That's all I have to say.
Okay, well, the state will have an opportunity to be heard if we get to that point, because I want to make sure I understand. This is a motion to withdraw that Mr. Silverberg filed and is seeking a young hearing. This is not Mr. Handte seeking a Ferretta hearing for the ability to represent himself. That's a different hearing. So it's the court intends to review, consistent with Young versus State, what the nature of the dispute is, whether the relationship is so fractured and how come, and take into account other things like the procedural posture of the case, how soon the trial is, and other matters. So that's what I have to say. But with respect to the court's laundry list of issues that need to be addressed, nothing further.
No, thank you.
Okay, Mr. Silverberg.
No, Your Honor.
All right, thank you. Mr. Hillygus.
I do want to make a statement that I do not consent to contract with this court. And I do have a couple questions. Are all men created equal? Is it true that no man is above the law? Are you above the law? Do you follow judges' orders? Is this court a court of law? Do you follow the
So
common law?
Mr. Hillygus,
as cited in
Mr.
chapter
Hillygus, this is
1
going to be an
of
example.
NRS?
This is going to be an example of me asking you to please stand down on this, because this is not responsive to the court's questions.
Is the common law cited in NRS, and do you follow the common law?
Mr. Hillygus, this is going to be the last warning that I'm going to remove you from this courtroom on very important matters. You're going to step outside anyway so I can talk to Mr. Handte and Mr. Silverberg. But right now, I want you to focus on the issues I just raised. I want to make sure you heard what I said, you realize those are issues I want to go over.
Well, I didn't challenge jurisdiction, but I just want you to know that there is a judgment, a three-judge judgment that's...
Three justices.
3 judges have issued a judgment against you for default under the common law. And if you haven't read it, it's been put onto the public
I just
record.
told you there are 3 justices. I just corrected you. There are 3 justices. I've read it. And it's been filed in.
That was in the private. That was sent to you through the private.
It has no,
Put it
Mr.
into the
Hillygus,
public.
it has no legal effect on what we're doing here right now. It's not going to
Well,
stop.
it does, because now there's criminal allegations that have been made, you've remained silent, so you've consented to the contract. There's criminal allegations, you're facing an indictment, a grand jury indictment. You cannot proceed, you've got a conflict of interest, you've got a judgment against you. And so this case shall be dismissed because I've not committed a crime. I'm being held against my free will. There's multiple Fourth Amendment violations that have been committed against me. And I can raise those and explain them to you.
Well, we're
But
not
I
here.
was
Okay,
arrested
Mr. Hillygus,
in
Mr. Hillygus,
California
Mr. Hillygus, that's enough.
without a warrant.
Okay,
I was
understand.
arrested in Missouri
Mr. Hillygus,
without a warrant.
this is the final warrant. These are a warning. You made these points before. And the fact that there's a new judgment by 3 justices against the court, and I realize that's something that
Well, it's more than just the court. There's quite a few defendants
so
and
you-
respondents.
So earlier when I said that your challenge to the court's jurisdiction has been noted and made of record, and if your position now is, Judge, this is some new information, new situation, I want to make sure everyone's aware, this is not the time or the place. If you believe that there's a legal basis for this case not to go forward in light of something that's happened somewhere else, you have to file a motion, let the state respond, I will consider. But right now, we're focused on these pretrial matters.
As one of the people, I do not file motions. I call for a court of record under the common law. Is this a court of record under the common law?
Okay, I understand your position. So here's what we're going to do. I'm going to ask everyone to please step outside. I'm going to have a closed hearing where I'm going to discuss with Mr. Silverberg and Mr. Handte the nature of their relationship, and then I will have the deputy let people know when they're able to come back in. For those that are recording these proceedings, make sure please the camera is off and the camera operator steps outside as well. Mr. Hillygus, I'm going to ask you to, also the deputies to escort you outside of this.
Judge, sounds like always clear.
It's clear. Okay, we'll go back on the record. For those that have previously requested permission to record these proceedings, they may begin recording again if they so choose. The court has held a hearing pursuant to Young versus State and determined to deny the request for Mr. Silverberg to withdraw. Mr. Silverberg remains appointed counsel for Mr. Handte. Trial goes forward. Next, pursuant to Nevada Supreme Court Rule 230, the court is aware that there is a presumption that courtroom proceedings are open to the public and are subject to electronic coverage. In the event that the court determines that that should not be allowed or should be limited substantively, the court is generally directed to consider factors such as the impact of coverage upon the right of any party or witness, the impact of coverage upon the safety and well-being of any party, witness, or juror, the likelihood that coverage would distract participants or would detract from the dignity of the proceedings, the adequacy of the physical facilities to allow such electronic coverage, and then, of course, the catch-all, any other factor which would impact the fair administration of justice. Now, we have counsel here, Mr. Busby. I think you're here on behalf of our Nevada judges.
I am, Your Honor.
All right, feel free to come forward. I'm gonna, just because there's an empty seat here, you know, have a dog in this underlying fight. You're here to talk about access to the proceedings. If you would please take the chair available there.
Yes, Judge.
And would you, again, just state your name for the record, spell your last name, and tell us who you represent.
Yes, Your Honor. Luke Busby, B-U-S-B-Y, bar number 1319, here representing our Nevada judges.
Very good. And then I understand that Mr. Conrad from This is Reno has an interest in electronic coverage of these proceedings. Are you here, Mr. Conrad?
Yes, sir.
Mr. Conrad, Dr. Conrad,
Yes, sir.
nice to see you. Do you have a pending request to coverage this electronically by video? If you do, have you talked to our Nevada judges about access to the common feed, anything? Or tell me exactly what you would ask the court to do today with respect to your comment.
So typically we do a full video, and if our Nevada judges is good with doing the video, we would just request audio and photographic access.
Okay. Let me do this. Well, let me ask this question. Is it something you want me to order? Do you want to have time to talk to Mr. Busby? Or if you have a legal representative, talk to Mr. Busby? Do you want to monitor the hearing? Do you want to be put under oath and explain that if you're allowed to be involved at the trial, that you'll abide by all proper procedures, not video or in any way interfere with the administration of justice? I mean, things like that, or what do you want to do?
I guess I would just request access, either photographic and audio access, and whatever I need to do that. I believe I filed a request to cover this hearing today, and I'm happy to file a similar one. For
Okay, and did we grant the request for today?
I don't believe I ever got a response.
Okay. Well, I've allowed our Nevada judges, they've been here for multiple times. They're familiar with the rules that apply to this type of a proceeding, the limitations. They've been, as far as I can tell, professional in the manner in which they've conducted themselves. What I would suggest is this, to collaborate during a break with Mr. Busby and or his client and talk about a way that you can collaborate. If you asking me to grant permission to you and your company, I would need you to certify you're familiar with our local rules, you agree to follow them, And generally, we require one feed and everyone to work together to figure out how to use that collaboratively. We don't have two cameras in at the same time, if that makes sense to you.
It does make sense. The hearings that I've covered prior to this one, typically, again, it's one video feed, and then there's sometimes a photographer separately because still images and,
To get a still photo.
yes, sir.
And again, we're talking about this hearing, maybe Monday, next Monday, and then maybe the next Wednesday, and then of course the trial, right?
I don't know my schedule off the top of my head about what all I will be covering in the future. I would like access to the trial, so when I get that in front of me, I'm happy to file that request with the court.
So for today, you'd say you'd like me to order that you can do that which you requested previously, but we didn't get back to you?
Yes, Your Honor.
Are you aware of the request, Mr. Stege?
No, but I'm aware the rule requires the parties to be notified of it. Reading the rule here, it does allow, pooling anticipates no more than one television camera and one still photographer. But because of the notice requirement, I asked the court not to rule on that, but to require this agency, just like any other agency, to conform with the rules.
Well, you heard Mr. Conrad say that they made a request and either the court overlooked it or we meant to communicate back and it didn't happen timely. But so I don't want him to be shortchanged today if he otherwise would have been allowed to.
Well, right, but again, we have notice and an opportunity to be heard for
I
a reason.
understand.
If he does not comply with that, or if the court doesn't, that does not, I think.
Shouldn't impact you.
No.
I got it. Mr. Silver, do you have a position with respect to this is Reno?
Your Honor, we don't object to any of the requested coverage.
Okay, thank you. So, Mr. Conrad, here's a little bit of a pickle the court's in. For reasons I don't know as I sit here, we didn't timely communicate the request to both sides. And so they didn't have a chance to decide what their position would be, such that the court could weigh that factor in whether to allow This is Reno to report video or still. So the request, to the extent you're renewing it now in open court, is denied. And that's, if you want to be upset with how we handle this, be upset with me, not with any of the parties here. For some reason, we overlooked that. I don't know why it wasn't communicated to you, but I can tell you this. If you submit another request to us, email. I'm not sure if there's a form now that the Second Judicial District Court is using, a standard form for all departments, or rather it's an email to the court administrator, Alicia LaRude, but she's been forwarding them to the departments promptly, and we turn it around rather quickly. So if you want to be here for Monday, the 21st, or Wednesday, the 23rd, get those to the court quickly, and then on Monday, the 21st, I'm going to make decisions with respect to whether cameras will be allowed in the courtroom for the trial. Do you understand?
I do understand, and with all due respect, I did file this a couple weeks ago. I sent it exactly to your point to the court administrator. She confirmed receipt, and so I believe I've done what's...
I don't know what happened. I can tell you this, not to justify if we overlooked it, but to give context. I just finished a nearly 2-week murder trial, and your request may have came in during the middle of that, and I may have just overlooked it. So I cannot prejudice the state's rights or the defendant's rights, so I'm going to have to politely but firmly say I can't let you record or take stills from today's hearing because I haven't approved it after input from the state. I will assure you, however, if you make a request going forward, the court will give it immediate attention and respond promptly. That's the best I can do, Dr. Conrad. Okay? Thank you. Let's move forward. Motion to confirm. Oh, beg your pardon. Mr. Busby.
Thank you.
All right, what would you, do you want to make argument? Do you want to call a witness? Do you want argumentative judges to somebody to testify and how familiar they are with the rules and agree to follow them? I see it looks like your client representative is here, the principal. If you want the court to hear from him, you can call him as a witness, and I'll certainly consider whatever he has. Of course, both Mr. Stege, Mr. Silverberg, and Mr. Hillygus can ask questions of him if they want to.
Yeah, Your Honor, I think that's appropriate in the circumstances.
Sure.
I'd like to initially call Mr. Alexander about comments.
Okay, sure. Please come forward.
solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. Thank you. Mr. Falcone, welcome to Department 8. Please have a seat. Mr. Falcone, please make yourself comfortable, slide in. You can actually take the microphone and adjust it. And you can even add another blue book underneath the microphone if there's one up there, if it's not high enough for you.
Should be good. Should be good.
All right, when you're ready, please tell us your name and spell your last name.
Alexander Falcone, F as in Frank, A-L-C-O, N as in Nancy, I.
Thank you very much. You may proceed.
Thank you, Your Honor. Mr. Falcone, can you please briefly describe for the court our Nevada judges, what it does?
Our Nevada Judges is a nonprofit corporation recognized by the IRS as a 501c3 organization. We provide electronic coverage of judicial proceedings.
And how many proceedings have you provided coverage of for since?
We have published over 600 hearings.
Are those hearings exclusively in Nevada,
Yes,
in state court?
yes,
Okay. Have you ever had any complaints against you?
no,
Have you ever had any allegations of misconduct issues related to your coverage?
none that were sustained by the court.
Okay. How many jury trials does our Nevada judges cover?
5,
And do you understand the rules as prescribed under SCR 230 for the scope of coverage?
I do.
Can you describe for the court very briefly your ground rules for providing coverage at jury trial?
We provide comprehensive coverage of the trial from beginning to end, and we do not record the jury.
Okay. Can you explain to the court why our Nevada judges would like to record this proceeding in particular?
This particular proceeding is one of our high interest cases. Part of it is because of the guardianship issues that are being discussed in the case and the history of this state with guardianship scandals in the past. And the other part of it is there is national attention on guardianship because of the Britney Spears issue. Then there's also issues of public interest, of a special public interest in, I don't want to use labels, but the manner in which the defendants are defending themselves. There's labels out there, and there is public interest generated in that specific type of format.
Will your coverage have any bearing on any right of a party to receive a fair trial in this matter?
It hasn't before, and I don't anticipate it'll happen now.
Will your impact coverage impact anybody's right to privacy, any party or witness?
No. In fact, when sensitive personal identifying information is mentioned, we redact it.
Including, excuse me, to ask a question, Mr. Falcone. So if a witness takes a stand and they say, they're asked their name and they tell us, do you redact out the part?
We could if you'd like to, but what I would say is like where they live, phone numbers. We don't want the public to contact them, send them emails and letters and stuff like that. We could redact the name too if they would request that. The only time I would be hesitant to do so is if the witness were a public figure, perhaps a government, like a police officer or something like that. And there would be, of course, exceptions for them if they're in particularly dangerous lines of work, like undercover operations and stuff like that.
Okay.
There are always exceptions, but generally, we want to provide the public the information and the educational value of the manner in which this department and this district conducts itself without interfering with the trial process, without causing safety concerns for jurors, and without causing participants to be harassed.
One or two more questions, and I'll turn it back to Mr. Busby. Have any of the 5, did you say you've done 5 jury trials so far?
5 jury trials.
Have any involved a self-represented person or persons?
Yes, and that one was particularly difficult for District Court Judge Michelle Levitt for a long time. But in the end, it went to completion. There was a verdict. I understand that those cases are particularly difficult, and I have certain things that I do. For example, I am very hesitant to cover them live when it involves a pro se litigant. And if there are direct camera antics, I will edit them out because I'm concerned about, the camera is supposed to be a fly on the wall. So when litigants look directly at the camera and are drawing their attention away from you and the attorneys, that's something that
That's what we want to avoid. That's the whole idea of why the court sometimes exercises discretion. They think that that's going to change the way people would act.
One of the things that's difficult is sometimes the litigants don't want coverage, and to create a situation where a litigant could misbehave just to thwart media coverage and camera access, In my opinion, that's also problematic. I think a lot of this comes down to
I
trust.
don't, I'm not really concerned with any of that in this case, where somebody would act out to interfere with the ability to cover.
Right.
But on the other, by the same token though, sometimes people will act differently because they are encouraging, or because they know that this is being recorded or will be published. And that I want to avoid too.
Right, and there's a certain level of trust that comes from the different roles that we serve. And I would hope that our track record with other very difficult cases is not the first difficult case, but I will concede it is one of the ones that's, towards the top. There's a certain element of trust there in what we're going to publish and what we're going to encourage and discourage, because I'm very mindful of that. Even sometimes, I've had a situation where an attorney will look at the camera, do a thumbs up and stuff like that, and I remove that.
Well, that would be inappropriate.
This is an example of something that I make sure I remove in editing.
Okay. Are you asking to live feed this or
No,
just record and publish?
This is not slated for live
Okay,
coverage.
fair enough. Please continue.
Thank you, Your Honor. And Mr. Beckman, continuing down the elements under Rule 230, will your coverage have an impact on the safety and well-being of any party?
Can I-
juror?
Can I ask you to speak up? You're a very soft-spoken man,
I'm sorry.
which is good for life, but sometimes you can, if you set it right in front of you there
Okay.
on the table, I should be able to hear you
Do you
better.
mind if I sit down?
I don't mind at all. Thank you for asking.
That should help. Mr. Falcone, will your coverage have any impact on the safety and well-being of any party, witness, or juror?
No, and if any of the attorneys have concerns about a particular witness, please let me know and I can keep the camera back or off of that particular witness if they have anxiety or something like that. So I'm very mindful of the fact that the camera could impact testimony, and I will do what's necessary for a particular witness to make sure they feel comfortable. Just as I mentioned before, I'm just hesitant when it's a public figure or somebody who works for the government who's on a salary. I can still do that, but then the public doesn't notice and it does sometimes trouble the public.
Okay? Also, sorry to interrupt. You heard, and probably for the first time, everyone may have heard, that the court is considering impaneling an anonymous jury. So in the other trials you've done, Mr. Falcone, have you taped as well the jury selection process?
No, someday I would like to, but I do not intend to do that for this case.
Okay. So whether it's an anonymous jury or not, it's the same response.
No matter what, we're
No
not
matter
going
what
to
you
cover
don't-
that.
You don't do it. Okay, thank you. Please continue.
Thank you, Your Honor. And Mr. Falcone, I think you've already addressed the issue of whether your coverage would distract participants or distract from the dignity of the proceedings. Is there anything else you'd like to describe for the court about your procedures when you're actually filming that may allay its concerns about whether your coverage would be disrupted in this case?
I'm very emphatic about our fly on the wall policy, is that we're to be noticed as little as possible. And to the extent that the court has any concerns whatsoever, paramount for the Nevada Judges Corporation is to cover the trial, but there are things that we can do to alleviate the court's concerns depending on what those concerns
So
are.
let's say something happens during the trial that I have concern about. How do I get your attention, Mr. Busby's attention, or the camera operator's attention? What's the procedure there that you would suggest?
Well, first of all, for this specific trial, I do intend to personally supervise the
Okay,
recording.
as in be here for the whole trial or most of the trial?
The only exception is one day when I need to record District Court Judge Sandra Unsworth, and that's the only day, which would be a portion of Friday.
Okay.
And
But the other times you would generally plan to be here?
I will be here, and you'll have his contact information in mine, admin@ournevadajudges.com. I don't mind if the public has that.
So if an issue came up, we'd go right to the big guy here.
Yeah, I want to educate and inform without interfering with what you're doing. Okay, you're doing very important work, and I hope that you understand that we're just trying to teach the people without getting in your way.
Understood. Thank you. Please continue.
Thank you, Your Honor. Mr. Falcone, are there any issues with the adequacy of the physical facilities of this court for this particular proceeding?
None whatsoever.
And is there any other factor that you think where our Nevada judges might do something that would interfere with the fair administration of justice in this case?
I would, under no circumstances would I allow that to occur.
Okay. Thank you, Your Honor. I have no further questions for the witness, and we respectfully ask that Mr. Falcone's request to be granted.
Okay. Thank you. One more question, Mr. Falcone. And then I'm going to ask Mr. Stege if he has some questions for you. Then I'll ask Mr. Silverberg and I'll ask Mr. Hillygus. You were here, or I think you were aware, because I'm remembering a communication, I think from our Nevada judges afterwards, where Mr. Hillygus stood up and ripped something up, and I think playing to the camera or directing it toward the camera. And afterwards, I seem to remember a communication from our Nevada judges indicating that no intention of including that in its online available transcript of the hearing.
Correct.
Do I have that right?
Yes, you have that correct. There was a portion where the paper was torn and he turned, edited out was the portion where he turned and looked at the camera. It's difficult because we do want the public to see what's occurring. So I tend to not want to remove something that's recognizing, that allows the public to see the difficulties that the court is actually going through. But the portion where he turned and looked at the camera was edited out. Was it a concern to you that the torn up portion was still in the footage? Because that's something that we can, it's tough. These cases are tough. These cases are tough. It's not the only one.
Well, you've impressed upon the court that you're trying to do the right thing. That's really the one of the court's main considerations. Mr. Stege, any questions for Mr. Falcone?
Yes, please.
Go right ahead.
What is the scope of your viewership as it relates to this case? Or size?
Would you like the analytics? I have them on my phone.
Or maybe you could speak of that in general terms.
In general
Right,
terms.
hold on one second. So I want to make sure you're asking a question that informs the court, but also we're not asking for, it's not, you can't ask a rancher generally how many head of cattle do you own, because that's like asking somebody how much money you have in the bank. So if it's a sensitive, business or interest or financial, let us know and I'll.
It's not, I don't
It's
mind.
not, you don't mind, okay.
Well, and YouTube analytics are generally viewable to the public, correct?
They're not, but it's okay. I share mine, so don't worry about it. So views, we have about 2.5 million. Watch time minutes, we have about 33 million watch time minutes, just counting YouTube. Facebook's analytics are a lot more convoluted. I would guess it's an additional somewhere 20%. The demographics are what's interesting. They're not youth that are watching the videos. They're, from what I can see, academics, people who are busy, they have jobs, they are interested in the court system, they would observe the court proceedings if they could. Unfortunately, they just don't have the time to. And we're talking, my biggest demographic is 55 plus, second biggest is 65 plus. So the people who are watching the videos are people who I believe have very busy schedules, full-time jobs, are earning salaries, and are interested in the operation of our courts. Most of it is Nevada, with a very small percentage of it being the rest of the country and other countries. In fact, this state is actually impressing upon countries like Greece, the United Kingdom, Ireland, Australia. You're actually having quite an effect on the rest of the world by allowing people to see comprehensively the proceedings. We have a very unique format. I don't know if you're aware, but we've been covering this case since 2019, every single hearing. And what it does is it allows viewers to sort of learn, instead of just, here's a small little bubble of time of what happens in court, the context throughout the years of what's going on. Interestingly enough, any court can thwart camera access, but it really can't thwart discussion of a case. And what the camera seems to be doing is causing the viewers to get a very accurate picture of what's actually going on in the case. And overwhelmingly, the public appears to support, generally, the judiciary. I'm not giving specifics about this case because that's not my intention to do that.
Well, and the intention of my question is, across your platform, this case in particular, I think you said it's your most popular.
This case is neck and neck with two of our other cases. They're very close to the top.
And so if the court were to think about, well, what impact on the community this would have, what is your estimate of the number of people your coverage would reach in, let's say, the state of Nevada?
Oh, I would like to say that most of the citizens watch our Nevada judges. I would be surprised if it was between 5 and 10%. We're not large enough yet. Yeah.
You did mention, and for the purposes of sort of the court's consideration, that there would be a delay. This is not a live feed.
This will not be a live feed. And if you're concerned about the exclusionary rule, I could delay publication until after the verdict. The public will probably be somewhat upset about that, but it should be fine if that's a concern that you have.
Well, my question is, what delay did you come to this hearing anticipating?
It's actually a delay of just the fact of how long it takes us to edit. So it's kind of self-imposed. Usually we can get, say we do a full day, you might see part one the next day, which is like 2 hours of the day prior. So there's, beyond the first and second day, there's just gonna be a delay because of editing.
And that brings me to my next question. You have mentioned the ability to, and your own desire to edit portions of the proceedings. I want to ask you how long that takes, or like, how much do you, say the last court hearing, how much did you have to edit?
It's about, I would say a rule of thumb would be 2 hours of editing for every 1 hour of footage, and that's only because it's me personally handling it. If somebody else does it, it's even slower.
Okay. And so you were asked by your attorney what, basically your opinion on the impact on the jury, but you don't really know the jury's ability or the veneer's ability to go onto your website during trial.
Right. We haven't had any issues in the past. There was one sort of odd issue with the very first jury trial, if you'd like me to go into and explain.
Please.
So with the first jury trial, there was opening statements were covered, and it wasn't a juror, it was one of the witnesses for the state saw the opening statements, contacted the prosecutor about some new piece of evidence they had, and then they provided that new piece of evidence to the state. I do recall District Court Judge Christina Silva mentioning that it wasn't a problem with the media so much as a problem with a new piece of evidence being provided, and if the state was going to insist on using it, they would have to schedule a new trial date. That, of all the situations, that's the only thing that's ever happened.
And is that the most sort of serious sort of, not conflict, but issue you've had involving trials?
Yeah, that's it, you know. It's tough because we didn't do anything wrong, but arguably, if the camera wasn't set there, the witness would have never seen it, would have never sent anything to the state.
And although I am not suggesting this, but you are willing, if asked to, delaying publication until after the verdict, or some number of days delay in publishing the what happens?
Absolutely. Paramount to the organization is to provide comprehensive coverage of the trial. If that's something that we have to do, then we will do that.
And you're asked by your attorney about sort of the risk of danger to the public or witnesses or anyone like that. That's, you don't really know anything about that, right? Like, you're not in law enforcement, you haven't done a sort of threat analysis in the case, correct?
Well, we have a good relationship with the prosecutors in Clark County. Just let us know and we'll take care of that.
Well, and what I want to touch on is you're of course aware of, like, there's been various threats made against public officials within this case by people interested in the case.
I am aware of that.
Okay, and you would agree with me that that could be amplified given the coverage?
I wouldn't say so because the problem is the information. So even if camera access is denied, the information is still going to be available by whoever's observing. Typically, because misconduct in these cases is connected very closely to the parties, removal of the camera, even sealing and redaction, often doesn't do much. My biggest concern is preventing harassment. So that's why the most important thing is the emails, phone numbers, stuff like that.
And you yourself have been party to, or not party to, the subject of or received some of the various harassing emails that have been sent out.
And that's also relatively normal. The most important thing, hopefully, is to judge me by what I publish and not so much the communications that I receive.
Right, and I'm not suggesting that, but I'm asking you to reflect on, this case has a feature that there are people out there in who knows where who are sending emails to a lot of people in the case, including yourself, sort of harassment being the main goal.
Well, he already acknowledged that that's the case.
Right. And so, do you have thoughts on how your coverage may or may not contribute to that harassment factor. I point out to you the flyers comparing this court to Nazis, calling people associated with the case baby killers.
Well, to be quite frank, the camera, those things are true, and I've seen those things. And the counter narrative provided by the camera is that when you thwart a third party from providing electronic coverage, that stuff is still being published. There's no way to stop that. All we can do is publish the truth.
And so you see your coverage as really being counter to some of those narratives.
You could say that, but I mean, it's not really our objective. The purpose of the camera is to record what's actually occurring in court, and we don't do commentary. So by seeing with their own eyes what's happening, they form their own opinion. It's very different than being told. Telling somebody what's going on in a case is very different from showing them. It has a very strong impression on the viewers to see for themselves the manner in which the court conducts itself and the participants.
And you've had no issues in this case with any of your covers? That's correct.
None whatsoever so far.
Okay. Well, thank you, Judge. No further questions.
Let's actually start with Mr. Hillygus on this, and then I'll come back to Mr. Silverberg. Mr. Hillygus, do you have any questions of Mr. Falcone?
I don't really have any questions. I just want to thank him for his coverage, and I believe it's important what he's doing to get the community involved in seeing how the court operates, and I'm all for cameras in the courtroom.
Thank you. Mr. Silverberg, any questions?
No questions, Your Honor.
I'm going to assume that on behalf of your client, you echo what Mr. Hillygus just said.
Precisely.
Okay. Any additional questions?
Nothing further, I would just ask for friends
Anything else that you'd like to say that if somebody had asked you the right question, you would have told us?
I think that all of the right questions were asked.
Okay. Anything else?
I asked questions, I didn't state my position.
Okay, well, I'll let you summarize where you are in just a minute. Thank you. You may step down. I appreciate you being here and responding to the court's concerns. So as Mr. Falcone makes his way back to his seat, I just want to observe this. You know, we're all aware that during jury selection, one of the questions the court always asks, and if for some reason the court overlooks it, counsel will ask is, have you heard anything about this case? Do you know anything about it? Have you seen it with directly or somebody mentioned it to you? Do you believe you know anything about it? Have you read any newspaper articles, gone online? Know any of the accused, know the prosecutor, know the court. So there is that, and they're under oath when they answer those questions. So to the extent that somebody would have taken notice of anything our Nevada judges or any other news media has posted, we would expect them to truthfully explain what they have, and then we'll discuss with them whether that would impact their ability to be fair and impartial. I wanted also, before each side summarizes their views, Mr. Hillygus and Mr. Stege on behalf of and Mr. Silverberg on behalf of Mr. Handte have already indicated they have no objection to this, and they're in favor of it. So that's noted. But I want to tell you that I'm still not going to make a decision on this till after the hearing, the Monday before the trial, after I determine whether this is going to be an anonymous jury. Now, having heard from Mr. Falcone that they don't record the jury selection process, that gives the court a considerable amount of comfort that shouldn't be a factor. But I'm still gonna just chew on this a little bit more, but I wanna make sure people know the court's decision at least a week before so they can govern their actions. But what do you think that this is showing the court and what the court should do? Then I'll ask Mr. Stege.
Thank you, Your Honor. Under SCR 230, of course, there's a presumption that electronic media coverage should be permitted. And we believe our Nevada judges, based on the testimony of Mr. Falcone, squarely meets the factors in favor of providing coverage with reasonable limitations as conceded by Mr. Falcone. And, I think his testimony did a fantastic job of allaying any concerns about the impact his coverage might have on the public, in that the antidotes to misinformation or threats or allegations against public officials or court, etc. I mean, the best antidote to that is the truth. And if the public can see for themselves what's happening in the court, it goes a long way in dispelling those problems on its own, Your Honor.
Well, I also heard him say that if the court grants a request, but orders that this not be published till the jury verdict has been reached, or if they're unable to reach one, I've excused them because they're at an impasse, because of concerns about witnesses potentially going online to see what other witnesses have said in violation of the exclusionary rule if invoked. And let's remember, the state can invoke it, either defendant can invoke it, or the court on its own initiative can invoke it. So it's likely to be invoked. I have not had a jury trial that I recall where it was not, so let's all assume it will be. And I understood Mr. Falcone to rather politely say that's not their preferred approach, but if that's ordered, they'll follow it because they don't want to interfere with the proceedings. So if that's ordered, I'll expect it to be abided by.
And thank you, Your Honor. Just to summarize Mr. Falcone's general position is one of being eminently reasonable to consider what the court thinks is important insofar as limiting what the jury, if the jury's filmed at all, that's my number one concern, that doesn't happen. And that Mr. Falcone will react reasonably to orders of the court within the scope of SCR 230 to accommodate any issues that do arise during the proceedings.
Okay.
And with that, Your Honor, we believe, because all the factors weigh in favor of media access, that you grant the request under Rule 230.
Okay, now you heard, thank you. You heard what I said. I'm really not prepared to make a decision on this until a week from Monday, which is a week before the trial. I know you wanted one today, but I may not come until 10 days from today. You understand that?
Understood.
All right. Mr. Stege, what's your position based on what we've heard?
I anticipate that the court's going to grant electronic access.
Well, you want me to tell you where I'm leaning? I'm leaning toward granting it.
Right, so they've been they've shown in this case, they are abiding by the rule. I expect the court to think about some of the things, the impact on the jury veneer is an issue in this case. It's been an issue in the case, particularly Mr. Handte and Mr. Hillygus seeking status as media darling.
Well, let me mention.
As well as the harassment piece.
Right.
So I expect the court will craft an order balancing those factors in allowing electronic coverage.
Well, thank you, and I'm leaning toward granting the request. Two or three things in particular stood out to the court. One was that Mr. Falcone is planning to be here himself for the vast majority of the trial. So if an issue arises, we can get his attention rather quickly. Two is not seeking to live stream. And then third, not the jury selection process. So those are three important factors. The other thing is that I'll have to give some more thought to the rule of exclusion. Well, let's go right to it. Does the state anticipate requesting a rule of exclusion on witnesses?
I've been a trial attorney for 20 years. I've never seen a trial bench or jury that wasn't invoked, and it will be in this case.
All right, so the state's invoking.
Well, yes.
All right. So with that understanding, I'll give some more thought to this, and I will pronounce on the record Monday, the 21st, what the court's decision is. But again, unless something changes in the court's thinking, the answer to that is going to be yes, coverage is approved. The court allows, well, let's back up. Ms. Falcone, you can avoid sending a written request in. Do you seek to be here for the hearings on the 21st and the 23rd?
Yeah, not personally, I'll send a
But have somebody here.
Yeah, I'll send a camera.
Mr. Stege, any reason the court should not allow that?
I haven't objected to any of them so far.
Right, granted. With respect to Mr. Conrad's on behalf of, if he seeks to do that, which it sounds like he's going to, please put that in writing, Mr. Conrad. I'm going to let the state look at it a little bit more, and then you'll have a decision on that just as promptly as we can. Mr. Conrad, do you have a question?
Your Honor, is the form going to be updated on the website so there's a little more clarity in this process? Because when I sent that email a few weeks ago, I thought I was abiding by everything required. Apparently I didn't.
Or you did and it just got overlooked.
Okay.
So what I would say is do what you're doing. In terms of the form being updated, I know it's in the works to have consistency among the different departments. I'm not aware procedurally or logistically where we are. But if you email Alicia LaRude, I'll make sure that we respond properly.
I just did.
All right. And again, I apologize for the disrupt that happened here. All right, let's move on. So anything else before I excuse you, Mr. Busby?
Nothing at this point, Your Honor.
All right, you're free to stay and observe, and if not, you're free to go as well. Same with anyone else that had an issue on this in this regard. Thank you. Wish you a pleasant afternoon. All right, exclusionary rule is invoked in the trial in this matter. Motion to confirm. Is the state prepared to go forward on the 28th?
I anticipate being ready to go forward, yes.
Or Mr. Hillygus, are you ready to go forward on the 28th?
I do not consent to this forum, and I don't believe that this court, as you know, they don't have the ability to move forward because of the all this stuff that is on the record. And so I do not consent to contract with your corporation.
Understand your position. Mr. Silverberg.
Your Honor, I don't believe that I will be ready. If Your Honor wants a written motion, I'll prepare that in light of both my own trial calendar and issues related to the Young hearing have hindered my ability to be prepared. Mr. Handte, I can tell Your Honor, feels the same way.
Okay, well, right now I'm not slowing the train down. However, if you file a motion, please file it by Monday, close of business, make sure it's not just electronically filed because it can take a few hours for it to be processed and then appear on eFlex. If you would provide whatever is filed, of course, courtesy copy to the court to Mr. Stege, and however, Mr. Hillygus is getting his messages as well. So that we all have it as quickly as it's filed. And then to the state, I'll give you 48 hours to respond to any motion to continue. And then I will take it up on the Monday morning, the week before the trial.
Thank you.
All right. Let's move on. Mr. Hillygus, you heard my preliminary comment. And by the way, I know that for my staff here, we've been here for close to 2 hours. If anyone here needs a short comfort break, please just get my attention and we'll stretch our legs. All right, let's move on. Mr. Hillygus, you heard when I sat down, I talked about having you dressed properly for court. I don't know if you've given that thought and you have a position on that you'd like to share, or you want to give it some more thought. I want you to be dressed appropriately for court. I can't force you to dress a certain way, but what I can do is, if you want to be professionally dressed or appropriately dressed for court, Mr. Handte, he can look like this, that's appropriate. He can put a suit and tie on if he chooses to do so. The study after study suggests, however, that if a jury learns that somebody's in custody who's accused of a crime, it generally works for their disadvantage. So if you're in jail clothes, then that's usually not a good thing. So I want to give you every opportunity to wear more appropriate clothes. Have you given any thought to that? And if so, can you tell me what your thinking is?
The state should provide a tailor, and I should be tailor measured for proper clothing, suit and tie, and shoes and socks and belt and the whole 9 yards.
So
that's what you're going to do is you're going to force me to appear at a trial. I need to be properly dressed.
Well, do you have clothes on your own? You're self-represented. You don't have an attorney on this case.
What you see is what I got.
And there's no, for example, there's no clothes in Texas or wherever you have your stuff that you can get here and that you want to wear.
The state needs to provide a tailor. They need to come in and measure me and give me proper suits and shirts and more than one, a shirt every day, and I need to be properly clothed. I agree with you. I don't want the jury to reflect on me as being somebody that's in custody. I'm a professional. I've 30 years professional for this state.
I got it.
I've never been
So
accused of a crime, and I haven't committed a crime.
Okay, so what I have to do is think about the best way to get this done, because I can tell you, I've never had a case where a self-represented defendant was somebody that the state was ordered or the county was ordered to provide clothes that was not represented. It's just a little awkward. I have to figure out what the procedure is. I may fashion an order directing the Washoe County Sheriff to use best efforts to get you professionally dressed and ready for court. Whether that involves having a tailor come to you to measure you up, that's not likely. To get you clothes that fit reasonably well and make you appropriately attired for court, that's likely what's going to happen. Mr. Stege, do you have any thoughts on how that might work?
I would be surprised to see an order directing the sheriff to do that. I think by practice, custom, and law, you know, the defendant has many allies, right? So that's usually provided by the defendant himself, his family, or his allies. If those three things strike out, then I would expect an appropriate motion before the.
Well, we're 17 days out.
Right. This man is expecting a tailor. No, there will be no tailor.
I would object to Mr.
Hold on,
Stege.
hold on. I'll let you go.
So I would suggest, rather than coming back the 21st, that this issue be, well, that between now and then, the defendant be directed to make efforts to and come back with a plan. Not just a passive aggressive, I need a tailor, but an actual plan. I reached out to my family and my allies, and I have or have not had clothes, because it is not supported by the law that the sheriff or the state would be providing clothes. And I do want to.
What about the court appointing the Washoe County Public Defender as standby counsel for the limited role of assisting with properly clothing Mr. Hillygus for the court proceedings?
Well, I would not deign to sort of speak for them, but based on what we've seen in prior hearings, I foresee resistance by them to such efforts. Now, if the sheriff is willing to do it, I imagine someplace they have clothes for people, for example, who come in with insufficient clothing, that they can, a closet for that, but I don't think we should make this a big issue.
What if Mr. Hillygus was indigent and he's self-represented and he couldn't afford nice clothes for court? I mean, somebody has to do something. So I'll figure out an approach here. Let me tell you the way I'm leaning. The way I'm leaning is we go two directions. One, that the court directs you, Mr. Hillygus, to use your best efforts to reach out to people that support you to help you with this. And two, the court reaches out to the Washoe County Sheriff and finds out what they're capable of doing. And then maybe I issue an order directing them to use best efforts. Best efforts is a legal term. That means to try really hard to get you fitted properly for court. Does that mean we're set for a 9-day trial. You understand one of our days for our 2-week trial is Labor Day. So we're set for a 9-day trial. Does that mean 9 new suits? No. Does it mean dressed appropriately for court? Yes.
I would object to any used clothes. I want new clothes. If you're gonna provide me clothes, I need to have due process. The state is trying to diminish my ability to look proper and wants me to be slavish and wear some used old clothes that don't fit properly. That's not who I am.
This man owns property, he can afford to be on the run for 9 months, and is protected by a whole group of sovereign citizens. So the idea that we're trying to hurt him by not providing him a tailor is inconsistent with reality. I do want to, the court mentioned with respect to Mr. Silverberg's motion, the state has 48 hours to respond, but we're not going to hear this until the Monday before trial. I like to humbly request, if we're doing it in that short of an order, we need a decision from this court in a hearing. The reason being, there's a lot of pieces in motion for this trial to occur, and to call it off a week before would cause expense.
Call on me. I have a 15-count sexual assault trial starting tomorrow at 10 a.m. And in addition to that, I have other matters on my calendar, even during the trial week. I will be able to give that issue very little time and effort, and that includes the court working nights and some weekends. What I would suggest is this: Mr. Silverberg needs to file this motion as soon as he can. The state should get its response on at least 2 days before the Monday hearing, before the Monday trial. That is the soonest I will be able to rule on this, because I want to give each side an ability to argue their position, not just put it in writing. So if Mr. Silverberg were to file it Monday, then you can have until Thursday, I guess, at the following.
I'm fine responding, I can respond probably in 24 hours.
So you
I
just
don't
need
like that I have to respond, they're gonna wait a Monday, hence, while both parties must prepare for trial, and if the court continues it, that comes at expense to the state. I am very sensitive to the demands of all the parties, and I'm just simply asking, if possible, to avoid waste in that regard.
So here, let me just tell you this, if you're, I hear you. It's not optimal for a motion of this importance to be ruled on by the court. A week before, we're supposed to pick a jury. That is not generally how this goes. The fact, though, that this hearing ended up today, and this issue became right, apparently organically, is a product of the court couldn't get this hearing really sooner. And so, I'm doing the best we can. That's all I can say. We're all gonna know the Monday before the trial. Okay, let's move past this. Mr. Hillygus, here's the court's directive to
I
you.
don't have any family. I've lost all my family. I don't have any family here to try to provide me any clothes. I don't have any money on my books to buy any clothes. I don't have the ability to talk to people that live in other states to provide me clothes. I'd like to be dressed properly, if that's what you're gonna do to me. Is you're gonna provide
Mr. Hillygus, I'm the one that's,
used clothes
hold on.
that
I'm the one
don't
that,
fit?
Mr. Hillygus, the court's the one that's bringing this up now. The court's the one, maybe you were assuming all along that this was gonna happen, but when somebody does not have an attorney and they're in custody, this is an unusual circumstance. So the court has to anticipate in advance how this is gonna go. That's why it was on my list of important things to go over with you. Let me work on fashioning a remedy here that makes sure that you're addressed appropriately for court. However, when I see you next time, I want to make sure that you can truthfully say, Judge, I reached out to the people that are in my camp, that are supporting me, that are helpful to me, that are friends with me, to see if they could help out some way.
Nobody's financially supporting me, I can tell you that. So I can reach out to people that know me, but they're not financially supporting me anyway.
Fair enough. I have to think about this. We're gonna make sure you're dressed appropriately for court. All right, let me move on here. Yeah. Okay. We're almost done with this hearing anyway, because the things I wanted to go over, and my staff needs a break anyway. The things that the court wanted to go over, we've gone over. The next time I see you will be a week from this Monday. We're gonna finalize the court's decision on electronic coverage of the trial. We're going to discuss the jury, anonymous or not. We're going to hopefully have an update for Mr. Hillygus about how and who's going to attire him for court. I want parties to give more thought to the court's thinking that Mr. Hante's ankle monitor will come off daily during trial weeks. I've already told you, Mr. Hillygus, if you're unwell or in need of a wheelchair for entrance into or leaving court, or while in the courthouse, I need some medical evidence that is necessity or indicated for you before I can allow that. I'm not looking to make it difficult for you to have it available if you need it, but I need to see a reason that you do need it. So get something on file or be prepared when I see you on the next Monday to bring that to the court's attention.
The Sheriff's Department has determined that I'm ADA, so I'm Americans with Disabilities Act. They're the ones that have provided me the wheelchair that is medically in my records there. I don't know what else to tell you, but I'm being denied an ADA advocate that I need for this case. I have an ADA advocate that works at the Sheriff's Department that comes and sees me and makes sure that I'm getting what I need, which they're denying me hygiene, I'm not getting showers regularly.
Well, hold on, I don't want to hear the list of things that the sheriff is not doing that it's supposed to. What I'm
Just a
saying is,
fact.
if I'm gonna allow a wheelchair, I need some good cause to allow, that's it. And
They're
so
providing me a wheelchair.
we're gonna button that up when I see you on Monday the 21st, okay? Do you have a position on that quickly, because
No.
we're gonna take a break?
No, I just want to correct the record. It was stated that there's a judgment and justices. That's, the record should accurately reflect, that's a fake legal document. There is no such judgment. It's more sovereign.
I want to make sure it's clear that what I was saying is I reviewed briefly the document that purports to be a judgment signed by 3 justices from the Republic of Texas. Okay, all right, with that, I will see everybody on the 21st at 9:30. Thank you. With that, the court will be in recess.
Thank you, Your Honor.
Thank you.
All rise.